back with the PI show, and it's that time of the show where we answer all your legal questions. And it's Viv's mailbag.
Good evening, viewers. How are you? Hi, boys.
Hi, Viv.
Evening.
So today we've got another question from our viewers. Thanks again for writing in. They're always a treat to read. Perhaps not so treatful for yourselves, though. You all seem to be suffering from various injuries. This one comes from Sophie in Paran. She says, "Hi guys, I left my 4-year-old daughter at after-school care last week and she fell over and broke her arm. I'm not sure how well supervised the children are, but I have been told that she was being very closely supervised. Is it possible that I have a claim against the school, especially for the medical expenses that I now have to pay? Thank you, Sophie." Harry, what are your thoughts? Or Tony? Harry.
It's a tough claim. You've got to get all the facts and get statements probably from other parents, but prima facie, it's a very, very tough claim. Liability is an issue. There's got to be some fault. There's got to be some lack of supervision. You've got to find out where the person fell over exactly, what the condition of the after-school care was. Even though those supervision, there might be some defective tiles or equipment, and you've got to take, dare I say, photos of the scene of where it is, so you can get an idea of the exact circumstances of the accident. And then the mother can sue on behalf of the child for medical expenses. Hopefully the broken arm heals and there's no ongoing problems. So it's a claim in effect for medical expenses, and there's a right to sue if there's fault.
Well, because, Harry, the only thing I'd add to that is because it's a 4-year-old child, the level of care is very, very high, but witnesses would be very significant because the child's too young. I mean, 4 years of age, she's not going to be able to tell you much.
No evidence from the child.
So getting a witness's statements, and if it's defective equipment or machinery, you'd want someone to go and have a look, maybe an expert.
But if there were just other people around,
the child, pretty good evidence. If you
predominantly children, though. I mean, would they stand as witnesses?
The parents or supervisor, someone might say, "Oh, look."
People are picking up and dropping kids off. So some of the parents you'd interview in terms of getting statements about their observations. But it's a tough claim.
Right, thanks for that question, Sophie. Thanks, guys. The next question we have is from Paul in Taylor's Lakes. He says, "Hi, guys. I'm a keen viewer of your show, and so I thought I would write in with a question." Thanks, Paul. "The other day when I was just about to step off the tram, a car sped past and nearly knocked me over, clearly ignoring the fact that the tram doors were open. I was just wondering what would happen if I had been hit by the car and it drove away so fast I didn't get a chance to take down the plates. Is there any way I could receive some benefits? I believe I may have a claim from what's called the TAC. You could be right, Paul. Hoping to hear from you soon. Keep up the good work. Thanks, Paul." Tony, what are your thoughts there?
I don't know if he's got much of a claim because, there's a lot of near misses and near hits every day of the week. But if he had been hit, obviously TAC picks up on unidentified drivers and vehicles. So
how do they pick those up?
Well, there's a provision in the legislation that says that even if you can't identify the car, provided you make the report to the police and it gives them an opportunity to try and investigate, that suffices to give you, statutory benefits, which would be medical expenses and also loss of income if you couldn't work. And if the injury was severe enough, you could sue for common law damages. So, he'd be covered.
But the important thing is there is provision for what's called hit-and-run drivers who, do cause accidents and injuries and then flee the scene of an accident and, just can't be identified. So the TAC steps into their shoes, but you've got to put them on notice that that's what you're alleging. There was a hit-and-run. If there's no report to the police or other witnesses, sometimes TAC gets a bit suspicious. Was there another car involved at all? But if there are witnesses and the matters are consistent, then TAC does step in and provide benefits, statutory benefits, and common law claims. So they're open for someone in Paul's situation.
So Paul, maybe seek advice from a lawyer if you do happen to get hit, which we hope you don't. The next question comes from Andrea. She writes, "My friend was attacked by a dog about 6 months ago and the dog has subsequently been put down. While her wounds have pretty much healed at this point, she's now suffering from panic attacks, especially when she sees another dog. She's been seeing a psychiatrist, and it is likely that she will continue to see a psychiatrist for some time. She's unemployed and is finding it difficult to cover her expenses of the psychiatrist. Is it possible that she has a claim against the owners of the dog? Would she be able to claim anything other than medical expenses if she does? Thank you very much, Andrea. Tony, what are your thoughts?
Yeah, look, I think the most significant point about this is you've got to identify the owners. I mean, you know, most of the dogs these days have got chips. So the dog would have been put down. You'd hope that the council's attended and done the right thing and
kept
they've
an
got a
identity.
record of, yeah. But I mean, I had a case where, you know, that didn't happen. So if you can't identify the owners of a dog, you've got no hope. Now, if you do that, let's say you do identify the owners, then the next step is you put them on notice. Yeah, look, I think it's a pretty good claim because these days the Dog Act puts a pretty high onus on people to make sure that their dogs are on a leash or that they're properly secured. They just can't wander off like they used to 20 years ago. So, yeah, the Dog Act is a pretty strict sort of legislation.
And you'd hope the dog owner's got some insurance.
Yeah, look, you'd think that, Harry,
Household
most
insurance
contents insurance would pick up the dog.
Household contents insurance.
Yeah.
Even if the incident arises outside their home?
Yeah, that
It
usually picks
extends
it up.
to liability that causes damage.
And is there
outside.
an upper limit that a person could claim?
Well,
to
what
cover
would
for?
happen is this: you'd need to have more than 10% psychiatric injury, which is not hard to get to under the AMA guides because it's a lot more lenient than physical injuries.
And that's the claim for pain and suffering.
Yeah, and that would be probably around 400 plus these days under the Wrongs Act. So, yeah, no, there's an upper limit.
And
but
you can claim as of right for economic loss and medical expenses. You don't need a threshold, but you do to claim for pain and suffering.
What happens in this situation? I mean, we see a lot of dog owners these days. You know, people love their pets and they see them wandering around the streets and the beaches. What happens if they don't actually have insurance and their
they
dog
could be
does
sued
attack them?
personally.
They can be sued.
Viv, and then in those circumstances, they could take their cars or houses. So they should really have insurance.
All right.
Yeah.
So dog owners, make sure that you have insurance at this point. You can love the fluffy ones as well as having insurance.
Look at the household contents insurance as a starting point.
Thanks so much, guys. Well, that's all we have time for this week. We look forward to having you tune in to us next week with Harry and Tony. Thanks very
Viv.
much.
Thanks.
Thank you.
Thanks.